Thank you very much and very good morning. Yes, before I proceed with my presentation, I would like to say thank you to the organizing committees or organizers of this conference, specifically to Tim and the rest. And before I proceed with my presentation, I do have a very small video clip what happened in Hong Kong a couple of years ago, where big data has been abused. Let's go.
The chief executive of Hong Kong's main cashless transaction card resigned on Wednesday. It comes after Octopus Holding Limited was found to have been selling customer information without consent to third parties for millions of dollars. The major privacy breach has called into question the effectiveness of privacy protection.
Every day, millions of Hong Kong residents use the Octopus cashless cards to buy anything from train tickets, groceries to parking. Now the CEO of Octopus Holding Limited, Prudence Chan, has resigned. It comes after she was held responsible for selling private data of nearly 2 million customers to 6 insurance companies without their consent.
Regrettably, after recent events, we all understand it would be difficult for Prudence to continue in her role as Chief Executive Officer of Octopus, and therefore the board has accepted her resignation.
The sale of personal data generated 44 million Hong Kong dollars, or 5.7 million US dollars. At a forum last Sunday, Assistant Professor of Politics and Public Administration at the Chinese University of Hong Kong, Dr. Wilson Wong, says the current punishment for privacy breaches is not severe enough for it to be effective.
Recently, there's only been one case of monetary penalty for privacy infringement. The fine was just a few $1,000s. But when you think about it, Octopus has sold citizens private information for $44 million, so a few $1,000s will not be an effective deterrent.
Lawmaker Emily Lau says the Hong Kong administration also needs to be held accountable.
I think the Hong Kong public needs to criticise the Hong Kong government for failing to protect the privacy of the citizens.
After the privacy debacle, the partly government-owned Octopus says it will delete all non-essential information on customers from its database. It has also pledged to donate the $5.7 million it made from selling customer data to a community fund in a bid to regain public trust.
So with that background, I will proceed with my presentation. And what I'll do in this short period of time is that to give a very general perspective, and then look at the what are the approaches adopted by countries around the world to protect privacy, and some comparative analysis towards the end of my presentation of privacy and data protection laws in Asia-Pacific countries. And I would like to stress the point here, the focus of discussion is on privacy and perhaps a little bit on security. So let's get started. This is nothing much. This is how McKinsey Global Institute defined big data. Data sets whose size is beyond the ability of typical database software to capture, store, manage, and analyze. Go on. How big? This is how IBM described how big is big data. And honestly speaking, I cannot visualize that 2.5 quintillion bytes of data. Perhaps some technical people should be able to tell us. And according to IBM, 90% of the data today created in the last 2 years alone, and it comes from different sources. Let's move on. It is big in terms of volume, velocity, variety, and velocity, according to OECD. These are the big benefits of big data. It can enhance research and development, data-driven R&D, developing new products, optimizing productions or delivery processes, improving marketing by providing targeted advertisement, and developing new organizational and management approaches or significantly improving existing practices. Those are the benefits of big data in a very general terms. Let's move on. that big data is already a big issue, and it becomes a bigger issue when the big data is in the cloud. So this is how big data is described by National Institute for Standards and Technology. Cloud computing is a model of enabling ubiquitous, convenient, on-demand network access to a shared pool and blah, 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 blah. That is the definition given by National Institute for Standards and Technology. Let's move on. What are the characteristics of cloud computing? On-demand SaaS service, broad network access, resource pooling, rapid elasticity measured service. Let's move on. These are basics, I guess. Okay, these are the issues: privacy, security, trust, and jurisdiction. And I'm going to focus on one aspect of these issues, which is privacy. This is what the European regulator says. Cloud without clear and strong data protection is not the sort of cloud we need from the regulator's point of view. This is what the UMCoRS, Information and Privacy Commissioner of Ontario in Canada says, more or less the same thing. The great new world of cloud computing offers many benefits, provided we take care of the security risks and privacy issues. Okay? There are three approaches adopted by countries around the world to protect privacy. One is to have a comprehensive legislation. The second approach is sectoral-based legislation. And the third one is doing nothing. There are still countries around the world which have done nothing so far to protect data or personal data of their people. You can see the colors here. The brown is countries that have enacted comprehensive legislation. Sorry, the brown. And blue is sectoral-based legislation, and the other color is that countries which have not done anything so far. So in this part of the world, in our part of the world, countries like Vietnam, Cambodia, Brunei have not done anything yet so far. All right? Let's move on. This is a summary of what is happening in Asia. I'm not going to read them, just a summary. Macau enacted the law. China has came up with several drafts. The latest was in 2007. India amended their Information Technology Act, and there are some new provisions in that IT Act about privacy protection. Indonesia came up with an academic draft in 2009, and Professor Edmund will be able to tell us the development perhaps. Thailand developed the draft bill in 2010, Malaysia enacted the act in 2010, Taiwan amended the old law and came up with a more comprehensive one. Korea did the same thing in March 2011, and the Philippines government enacted the law last year. Hong Kong and Australia amended the laws in June and December. In Hong Kong, partly because of that octopus incident. So Hong Kong law was amended, and some provisions of the law has been strengthened to protect personal data, specifically on direct marketing. And Singapore passed the law in October 2012. As I said in my intervention yesterday morning, that when I talked to government officials in Singapore 3 years ago, they said, no, we don't have any plan to come up with any law on this issue. But fair enough. In October last year, a law was passed. And in April 2011, New Zealand Privacy Act has been decided by the European Union as adequate for the purpose of transfer of data between Europe and New Zealand. Okay, let's move on. This is a comparative analysis of the privacy and data protection laws in some countries in Asia Pacific. Within Asia, data protection principles are the very basic principles that companies and organizations will have to comply when they collect and process personal data. All those countries provide for that, meaning that in their legislations, they have data protection principle, which include security principle, disclosure principle, purpose limitation principle, all those basic things. Rights of data subject. Rights of data subject, again, all those countries provide for that, meaning that customers are given certain rights under the law. And special enforcement entity, Taiwan does not have that, because in Taiwan, the law is being enforced by different ministries depending on the process. And the rest of the countries, they do have special enforcement authority. In Malaysia, it is called Data Protection Commissioner. In Singapore, it is called Data Protection Commission. Yeah? Interestingly, the next column, Singapore and Malaysian law give exemption to public agency, meaning that Personal Data Protection Act of Singapore and Malaysia do not apply to public sectors. And interestingly enough, in Singapore there is a separate regime to govern the public sector. And strangely, very strange, in Malaysia, we do not have a separate regime for the public sector. So we have a law to govern private sector, and there is no law for public agencies. And in terms of remedies, all these countries provide for civil as well as criminal remedies, meaning that you can be prosecuted and individual can take actions against the company. In Malaysia, all the remedies are in the form of criminal offences. If you do something in breach of the law, you will be prosecuted. And of course, the normal process will take place. Yeah? You have to be brought to court, evidence will have to be gathered, and you have to be proved. Your guilt will have to be proved in court. So in Malaysia, as I said, the remedies are in the form of criminal offences. So there are 13 new criminal offences created by Personal Data Protection Act of Malaysia. Let's move on. Mandatory breach notification. Someone asked this question yesterday. So the position is that the law in Korea and Taiwan provide for that. If there is a breach, you have to report to the customers. You have to inform the customers, basically. Yeah? And in Korea, there is a requirement for you to report to the authority if it involves significant breach. And significant breach is defined as a breach that affects 10,000 or more customers. Right? If there is a breach and it affects 10,000 or more customers, you should report to the authority. So, I have 5 minutes. Okay. Differentiation between personal data and sensitive data. Singapore does not differentiate sensitive data from personal data. The rest, they differentiate personal data from sensitive data, mediation to resolve disputes. There are provisions in Korea and Singapore, meaning that before you are going to court, you can mediate and resolve the issue. All right? And organizations are required to take charge. Organizations must designate someone to take charge of these data protection matters. And this is provided for in Korea and in Singapore. So every company in Singapore will have to have someone to take charge of personal data processing and to make sure compliance with the law. Okay, let's move on. Malaysia requires registration. Every company in Malaysia will have to be registered as data users. Right? So class action is allowed under the Taiwan law. Okay, let's move on. Perhaps we can read the hard copy, because in the interest of time, I will stop sharply. And PIAs, privacy impact assessments, are encouraged under the Korean law. Yeah, companies are required to undertake privacy impact assessment if new products or new services will have some implications on privacy. You are required to conduct or undertake privacy impact assessment. So the rest are basically the Singapore characteristic. In Singapore, there is a term used in the Act, reasonable person test. And under the Singapore law as well, they can register their numbers in this do not call registry. Customers, individuals register, and if their numbers are registered, parliamentarians are not supposed to call them. This is something like what US has. Okay, let's move on. Okay, I'm coming to the end of my presentation. These are some of my books, self-promotional slides. Sorry for that. Okay, I wrote a first book about cyber law in 1999, and I wrote first book on privacy in 2002, and I wrote specifically on personal data protection law in Malaysia in 2010. So with that, thank you so much for listening, and perhaps we can take questions after that.